Yes. Uh, I thought I would just, in your meeting book, I start on page 7, just a little background on what happened with the work group. I know you, Alex, and Representative Collier were able to participate. Judge Keller wasn't, and some of the other folks maybe weren't either. But as we've done in past sessions, we had a stakeholders work group. I've listed all the folks who attended. As Alex said, it met twice via Zoom. We were a little worried about how that might work. We did have over 50 people on the first one and over 30 on the second one, which was more than we usually do in person at a room in Austin. The exciting thing about that was we were able to include folks who normally can't participate, who are far away. And I want to give to judges, court administrators, as well as public defenders around the state, a special shout out to the 2 judges who were able to participate in both meetings. Judge Alma Trejo from El Paso. Obviously, this would have been an awfully long ways to go for a 2-hour meeting. And Judge Alfonso Charles from Gregg County. He's a former member, in fact, of the then Task Force on Indigent Defense. He's a district judge up in Gregg County, Longview, and is the current chair of the legislative section of the state bar. So that was, I think, a real nifty opportunity that these strange times allowed us to have. And thanks really to the whole staff, because it was a team effort trying to coordinate a Zoom meeting with 3 times the number we have on this call. It was pretty crazy. Following the listing of the members, we have the policy, the legislative policy the board adopted many years ago, really. And the whole point of this is the statutory directive that TIDC has in its enabling statute to provide recommendations for improving indigent defense in the state. That's the basic directive. And the guidance y'all provided in this policy, which was based largely on the State Bar of Texas's legislative policy, was that fall within our scope. It's within the Fair Defense Act, that it not be for a partisan or political purpose, and that there's adequate notice given to folks to make comment about a proposal. And of course, the next step from the work group is this committee, and from here, any proposals that y'all approve would go to the full board for consideration at their meeting a week from tomorrow. And at that time, although it's a majority vote today, the policy provides that it be a 2/3 vote of those in attendance and participating in the vote at the full board meeting next week. So with that, I would turn to page 12. And this, it's a somewhat lengthy document. Apologies for that. We had more proposals than we typically do. There's 10 new proposals, and then there are actually 4 that are holdovers from last session that were approved by the board but didn't make it through the whole legislative process. And we'll cover those briefly at the end of this, hopefully. Our plan is for a TIDC staff person to briefly lay out the proposal, to acknowledge the proponent of the idea if they're here. And I see some of them in the room right now. We invited all of them to participate if they wanted, to be available to answer questions that y'all might have. And so with that, Alex, I guess I'll just jump into proposal 1. I'm going to do the first 2, and we're going to kind of do a little round robin of staff members on these proposals. So the first one is a recommendation to conduct a statewide study of indigent defense in Texas. The idea, I think, came from the fact that this coming session will be the 20th anniversary of the passage of the Fair Defense Act of 2001 that created this organization. And really the thing that led to that was the 2000 Fair Defense Report that was commissioned by the Texas Appleseed and conducted primarily by the Spangenberg Group. Bob Spangenberg spent the summer here touring the state, going to, I want to say, 22 counties. He always marveled that no matter where he went in the state, it was always over 100 degrees, which from Boston was a bit of a shock, I think. But in any event, we've never had a comprehensive state like that in the 20 years since. There's been a lot of specific looks at different programs and areas, but not one like that. This one, the idea for this came from the Fair Defense Project, and Nate Fennell is here, as is Emily Garrick, I see, their executive director, if y'all have any questions about this idea.
I have a question.
Go ahead, Judge.
But is there going to be another presentation before the questions? How is this going to work?
How do you usually do it, Wesley?
I mean, usually we do just a little layout like this, and that's it. I mean, it was really, unless Nate or Emily feel like I've missed something in the layout, I think it's open for discussion or questions from board members.
Okay. I first of all, I want to thank everybody for all their work on this. I know it is always a lot of work and people volunteering their time. And I really appreciate you, Wesley, and everything you've done in the whole group. And I don't have any problem with this first proposal, but somebody, and I don't have my notes now, so I can't remember who asked the question that I was thinking too. We have the authority to do this without legislation. So what's the advantage of having legislation?
That's a great question. Yeah, maybe Nate would want to tackle it since he's the one going forward.
Well, Judge, yes, I think one benefit that we were hoping is that we could sort of, first of all, prime the legislature. I mean, I think if it's the legislature's idea to do it, then I think it might be a little more responsive to sort of what comes out of that. But I think that, you know, we think it's a good idea and that it would be great if the legislature would do it and also appropriate money for it so that it wouldn't come out of the TIDC budget necessarily. But I do think TIDC would have the authority to do one now if the commission wanted to take that up and I guess moot the proposal.
I think that funding is a good point, because this is probably going to be a couple of years where we don't want to spend a lot of money on things that aren't essential. And if the legislature wants to do it and want to fund it, especially, I think that would be a good reason to vote for this.
I agree. Also, 20 is a good round number to do a study. So.
Yep. That was my only question.
Okay. Any other discussion or questions?
Well, could we put in something about funding in it, or I mean, I don't want to try and change the language now, but could we suggest commissioning a study on the state of indigent defense in Texas 20 years after the passage of Fair Defense Act and funding the study? Because the other things typically we'll let, we have a set amount that we typically spend for studies each year or set aside for studies each year. And I don't know, I guess if the legislature wants us to do it, then we can just do it and pay for it ourselves too, though. I'm not gonna try and change anything, that's fine.
Okay.
Okay.
If I could just say one thing,
Yes.
Studies don't fare too well in the legislature, and to request funding on it, it's going to be a stretch. So I'm just letting you know that if it's something that you can do, you should do it. But you know, if the purpose is to raise awareness, then definitely file it. But I'm not sure about actual, request to do a study on you guys, from the legislature. It could be part of the interim charge, but in terms of receiving funding, it's going to be a tight year. And so I think that this is very important, but if we can do it, but don't have the high expectation that you're going to get reimbursed for it.
Well, I think you make a very good point. And that brings up something else I was thinking about. We have a large number of legislative proposals, and I think I don't know what the commission as a whole is going to do, but I think we might want to try to narrow them down to the ones that are most important. And if this is something we can do ourselves, maybe that's what we should do, and and save the legislative proposals for things that we can't do ourselves or we think are more important. But whatever y'all want to do on this one's fine with me. And we can just take it to the commission and see. What do you think, Representative Collier, or Chair Collier?
I think that, it's important to highlight the 20th anniversary and to question how far we've come since then and what the current state of indigent defense is. Absolutely. But in terms of realistic expectations, I think that you need to be prepared to take on this as your own. So if it's to make a statement or to raise awareness, then definitely file it and move for it with the understanding that it may not go anywhere other than a hearing and, discussion.
Okay, thanks.
If you all wanted us to, on the staff side, you could direct us to explore what this might cost and how long it might take and things like that. I mean, and we could come back to you with that if that's better. Of course, that's the committee's decision.
Yeah, I would say if there's general support that we should send it to the full commission, and there may be other ideas of how to make it work there. So, I mean, everybody's generally for the idea, it sounds like. Do we want to take these one at a time? Can we take them as we go forward? Each proposal, is that right?
I think so,
Wesley?
yes.
Okay.
Yes. I
So,
would recommend either taking no action or take action proposal by proposal. Mhm.
okay. So is there a
And
motion?
just to be clear, this is to just recommend to the full board.
Right. No, I get that. But we still need to vote to send it to the board, right? Okay, so is there a motion to move it on to the board? I can move it if you like.
I'm going to defer to Chair Collier on this. Whatever she wants to do is what I'm going to go with.
Okay.
I just think that, this is an issue that is already part of my current interim charge. So it's part of the interim right now.
Okay. Well. All right. So are we just going to table it then?
I would table it for now and then come back if it's.
Okay,
if it's
let's do
something
that.
Okay.
Okay, Wesley, you got the next one.
Okay. The next one comes from Cynthia Garza, and I see she's with us today. Thank you so much for joining us. She's with the Dallas Public Defender. I'm so used to saying that. Dallas District Attorney's Office, Conviction Integrity Unit Chief. And they're seeking support for a proposal that they brought forward to the legislature last session. It was filed right at the end of filing and didn't really have time to proceed through the whole process, but it would basically require a court to appoint an attorney to represent an eligible defendant, indigent defendant, to investigate a claim for filing of a writ of habeas corpus in limited instances where the state believes that they have a potentially meritorious claim that needs to be investigated by a defense attorney. And at the nut of this, it's really just expanding an existing law, and you can see the statutory language down on page 16 that's suggested to require appointment if they believe that the person is, right now the law, requires appointment if the prosecutor represents to the convicting court that the person is not guilty or is guilty of a lesser offense or was convicted under a law that's been found unconstitutional by the Court of Criminal Appeals or the Supreme Court. So it's a very narrow appointment right now, and they've found that there are instances where there may be a meritorious claim. They can't affirmatively say for sure the person is not guilty, but that the person does need counsel, and of course they aren't in a position of the prosecutor to provide legal advice to a defendant in such a situation.
Wesley, could you speak up a little bit, please?
Okay.
I'm having
sure.
trouble hearing. Yeah, thanks.
Okay.
Thank you.
That was my full layout, so I don't know.
I heard it, it's just hard.
Okay, you heard enough. Okay, I'll try and speak up and talk
Okay.
to my left. I think that may be my issue. I think my mic is over there. But
Okay,
and so Cynthia's here to answer the questions and maybe correct me if I've gotten something wrong in my layout.
Okay. I think I understand it. Do you have questions?
my only question is about section B14, which is very broad. And our notes say that Scott Ehlers worked on this at the Harris County Public Defender and said it was a political decision to create a narrow opening for habeas case appointments, which this bill would widen. Well, if this is if that was a political decision, I think that would take it out of our realm and out of the scope of what our legislative proposals are supposed to address.
Well, I think he's using the word political. I was involved in that too. So I think he was using the word political generically, but it was to address a specific issue we had when we drafted 1174, which was there were at least one judge who would refuse to appoint lawyers when it was clearly an issue where relief was to be granted. And that was the impetus for the original legislation. Now, district attorney in Dallas and their public defender want to extend that to ineffective issues. I think it's appropriate, certainly if the district attorney realizes there is a meritorious ineffective assistance of counsel claim, that the defendant should have a lawyer to litigate that.
And what happens now?
Well, it's up to the judge. But I mean, in the previous case, it was the judge's position that, well, the defendant should just approach me or, contact me if they need a lawyer. And we didn't think that was sufficient.
So, but if judges can do this now, and you're talking about an issue with one judge that may not even be on the bench anymore, this really opens up the requirement to appoint counsel. But the main thing is I don't know what you think, what it meant by a political decision. I don't know what you meant when you said you didn't think it was a political decision, if that's what you were saying.
Yeah, I think the word political is generic in the sense that it was a specific issue that we felt needed to be addressed. Not that it was political in that it was either partisan or that it did not involve a court decision. This was clearly a legal procedure that needed to be in place. And I mean, it's been working very well ever since, because we work closely with the Harris County District Attorney's Office, and they often have situations like where there's a bad lab. We now have a police officer who they've investigated hundreds of cases on. And when we can get together with them and they say relief should be granted in this case, then it tells the judge right up front they need to have a lawyer for this person. This just extends it to a different issue, that's all.
Do you think that, I'm looking at the proposed language, do you, so the court, a potentially meritorious claim is any claim the court determines is likely to provide relief. So if judges are appointing counsel when they think that a claim is likely to provide relief, then we don't need this.
Well, to the extent that we're amending the statute, I think maybe, is Cynthia available to talk about that?
Yeah, so I was, the way that the statute, the proposed language here, this language in B14, this was drafted, the way that this came out, all this language right here that you see, this came out of Ledge Council. And when it came out of Ledge Council, this also went through the Legislative Budget Board. And so there was no significant fiscal impact to the state anticipated per the Legislative Budget Board. So I don't know if that makes any difference in terms of what is being considered here. This was passed basically unanimously out of the Criminal Jurisprudence Committee. Representative Collier was the chair. Representative Gonzalez carried the bill last session, and she has agreed to carry it this session as well. And so, we don't anticipate there being any significant fiscal impact this session either. So this language, this is exactly how it came out of Ledge Council last time.
And then it didn't pass. It didn't pass.
And it died in calendars because what happened was we were way too late because of our administration change.
Okay.
And so that's why it didn't get further than that, but that it was because we were too late to get to the table, basically, because of our administration change.
And so who proposed the bill in the last session? I mean, where did it come from? It didn't come from us.
It came from the Dallas County DA's office, and it was Representative Gonzalez agreed to file the bill. So she filed the bill and it was carried through her office. And so that's how it.
And would that happen again, do you think, this time?
Yeah, she's agreed to carry the bill this time.
I mean, if it comes through the Dallas County office, from Dallas, is Dallas going to propose this bill regardless of whether we do?
Yes.
Okay.
And she has Representative Jessica Gonzalez has agreed to refile it this session. Yes.
Okay, thank you.
Alex?
Thank you, Judge.
Yeah.
This is Jim Allison. As you noted in the discussion, we did not oppose this proposal because if the prosecuting attorney believes that it needs to be heard, then we agree that there needs to be a procedure for it. But I will point out that it doesn't have a state fiscal note, but it will have a local government fiscal note, that the county will be the one paying for the representation.
That's true. So any other questions about it?
No, I remember this bill from last session and I supported it. Of course, it did not have a fiscal note at the state level, but if they had an attorney during the original trial, it was a court-appointed attorney. And now I even think that it helps with judicial efficiency by ensuring that they have counsel to help prepare their writ. So.
Right. I mean, I think the quality control is that the district attorney is reviewing the case and saying, there needs to be relief here. And because the district attorney has no vehicle to make that happen, only a defense lawyer can do it. This expedites that process.
Right.
So is there a motion for this?
I make a motion to send it to the board.
Okay.
Full board.
To the extent it needs a second, I would. All right. All in favor?
Aye.
Aye. Judge?
I'm no.
You know. Okay. So it's 2-1. It carries. Next proposal is that Scott.
Yes, good afternoon. So this proposal is proposal number 3 regarding modifying Article 1517 to ensure magistration forms are properly preserved. This proposal is very similar to one that we brought to the board in 2018, and it was approved by the board. There was no opposition to this proposal this time around. The proposal was introduced and passed as SB 815 last session, and it was vetoed by the governor because the way that the bill was structured, it would have required the Texas State Library and Archives Commission to establish the preservation time periods for magistration forms, and the governor vetoed it because he said that he thought it was really more in the purview of the legislature to provide specific preservation timeframes for the magistration form. So this bill attempts to address that and set some specific timeframes for magistration forms so that they are retained for 3 years after final judgment is rendered or the proceedings are otherwise terminated in the case. Those preservation timeframes are based on the same timeframes for bail bond documents. And that is, that was taken from the Texas State Archives, Library and Archives Commission. We wanted to do that because magistration forms a lot of times have bail bond information on them. And so we wanted to make sure that those preservation periods were the same. So that's really the gist of this bill. It's really needed because, in our policy monitoring, we look at these magistration forms to make sure that that appointment of counsel is occurring timely. And if the forms are destroyed too early, then we won't be able to effectively do that in our policy monitoring. And there was no opposition. So that's basically it.
Any discussion?
I have a question. So who would be the one that would retain the records for the 3 years under your proposal?
Well, right now, they are really whatever judge creates the form. So JPs oftentimes are doing magistrations. There may be a magistrate that is hired by the judges locally. So it would be whatever judge creates that magistration form. We have last time when we brought this proposal forward, we suggested that the forms would have to go into the case file, but that brought some opposition from the court clerks. And so we stripped that out of the bill out of the proposal last time. So it really would just be whatever judge creates the form would preserve them.
And they would keep them separate from the actual case, or they would just keep a running count of all magistration forms?
Well, in some counties, they do transfer the magistration form to the case file per the county policies and procedures, but there's nothing in statute that requires them to put it into the case file. So the bill itself does not direct, who will ultimately preserve it. It just says they must be preserved. So I can just tell you what courts usually do in terms of who is keeping those documents.
Can they be preserved electronically?
They could be, yes.
Is that something you can include as the option, that they may be preserved electronically?
I would be happy with that amendment if you'd like to make that.
Well, I'm just giving it as an option. I don't know if that's something, you can say they can have them, as long as they have them, whether it's electronic or in paper form.
And that may be frankly covered somewhere else in the statute. I just don't know.
Okay.
I don't know. Jim is shaking his head yes, so he may know better than I.
Yes, this is Jim Allison. Yes, this whole thing, we supported this bill last time because we felt that we needed a definite schedule. The governor vetoed it without talking to any of us. I don't know where he got the idea, but the State Library and Archives Commission presently adopts and administers the local records retention schedule. So that's why it was put under them, just like every other county record in the bill that passed last time. And it has provision for electronic retention. You can convert any paper record to an electronic format under that schedule and statute. And there are certain records that have to be maintained in their original form. But otherwise, you can convert them. And this record would have gone on the 3-year schedule under the prior legislation. So we're just putting it in the statute clearly this time. It'll be on the 3-year schedule. Hopefully the governor will sign it. The present law does not get into who preserves the record, because as Scott said, we discovered there's some counties where the clerk does it, some where the magistrate does it. And when we tried to arrive at one location, we discovered that there were people who didn't want us, they had their system and it's working, and they didn't want us trying to create a one size fits all. So this would just leave it with the statement, it must be retained. And then the magistrate will be responsible for it unless they have another system. Then it could be, of course, delegated to the clerk, but it must be retained.
Any other questions, discussion? Is there a motion?
I move.
A second.
Okay. All in favor?
Aye.
Aye. Unanimously carries.
All right.
That's good.
Thank you.
Okay. I think Claire is next.
Yeah, this is proposal number 4. This is concerning Article 1517, which is about magistrate warnings to arrestees, which is their first opportunity to request counsel shortly after arrest. What this would do is clean up 1517 and clarify the duties of magistrates under it to rule on and transfer requests for counsel. So the first thing it would do is just break up and number the duties in 1517. Right now, Section A is a long block of text. This would break it up to make it a little easier to read and move around some of the text to fit that numbering. The other thing it would do is clarify that magistrates need to provide reasonable assistance in completing forms at the time of the hearing and transfer those forms within 24 hours of arrest. Those are both already required under statute, but this would add some clarifying language. And the last thing it would do is require magistrates to ensure that defendants can understand the hearing, and if they find the defendants can't understand the hearings, to go ahead and appoint counsel or to notify the appointing authority. This last part was added by our work group. They were concerned that defendants might not understand the hearing and then not be able to request counsel, and people who can understand the hearing might be in the most need of counsel to assist them with their case, especially comprehension issues due to technology problems or language issues were on the work group's radar. So they had us add this part of the proposal, but beyond that, they didn't really have major changes. They supported this concept. We ran this by some of the JPs at the Justice of the Peace and Constables Association and the Justice Courts Training Center, and they didn't have any immediate concerns with it either. So yeah, we pretty much reached consensus with the work group on this one.
Any questions?
No, I think that whenever you're presenting this, just remember that there's certain people who don't, who have concerns, have raised concerns about JPs who are not licensed attorneys. So I think I would, present this in the way that it's also providing notice to the person that the same type of notice that a law enforcement officer would say, you have a right to remain silent. Anything you say may be used against you, is what you're asking the magistrate judge to notify the defendant as well. So I think that it's just another reminder to the defendant of their right to remain silent at that point. And definitely make sure that the court is fulfilling its duties, not practicing law or anything like that. You want to make sure that we're not telling the JPs to practice law by giving advice. This is not giving advice.
Right.
I think it also makes 1517 a lot easier to read. It's a very difficult statute when you look at it. It's like one big block of words, and this breaks it down a lot better. Anything else?
No, nice job rewording it.
Okay. Is there a motion?
I'll move to adopt number 4.
Okay. All in favor?
Aye.
Aye. Passes unanimously. Okay. Claire, you want to take the Rothgary one?
Yeah, so this is number 5. The goal of this proposal is to codify the Supreme Court case Rothgary versus Gillespie County from 2008. That was a case that originated in Texas. And what Rothgary is about are appointment timelines. So as it is in Article 105.1 of the Code of Criminal Procedure, counsel needs to be appointed after the initiation of adversarial judicial proceedings, but it doesn't say in the code when that is. And what Rothgary said is that, and the text from the decision is in your notes, but basically what it said is that the Article 1517 hearing marks the start of judicial proceedings, and counsel needs to be appointed within a reasonable time after that and before any critical stage. So that's what we have in Section C here of Article 105.1, and the work group helped modify this language to make sure it tracks the holding of Rothgary and doesn't appear to require that counsel needs to be appointed before or at magistration, but within 1 or 3 working days after that. Article 105.1 was around before Rothgary, so this would update it to match the holding of that case. Where the work group could not reach a consensus, especially was around Section J of 105.1. Right now, J has a different timeline for defendants who are out of custody. It says that appointment of counsel for those defendants is not required until the first court appearance or when adversarial judicial proceedings are initiated, whichever comes first. Our thought as staff is that seems to suggest that proceedings might start after the first court appearance, and Rothgary made clear that that's not going to be the case when people are magistrated. It also indicates that appointment doesn't need to happen until the first court appearance, when really appointment needs to happen before that appearance because it's a critical stage of the case, which is also a constitutional standard. But work group members were concerned that having the same timeline for in custody and out of custody defendants would have a fiscal impact on counties, and that the 1 and 3 day timelines in Section C aren't specifically required by Rothgary, which just has a reasonable time standard. So ultimately the work group didn't reach a consensus on this one, but this is still one that's important to staff as something that can improve appointment timelines. As with the other proposal I just talked about, we see that counsel isn't appointed timely after magistration. Those requests aren't ruled on, or defendants are told they don't have a right to counsel until the first court appearance. And we think that this change would help clarify what those timelines are and improve appointment practices.
I have a question, a procedural question. If no consensus was reached by the work group, why is this properly before us?
Leslie, you'd have to answer that. What's the rule? I don't know.
Wesley, you're muted.
Oh, he's muted. Is he talking?
Yeah, Wesley, I think you're on mute. There you go.
But y'all didn't hear me. I don't think this is spelled out in the legislative policy. It just says that the committee, the Policies and Standards Committee may create a work group to assist in developing proposals. And it says, let's see, yeah. I don't think it spells this out. But we have brought things to you before that didn't have full consensus. I mean, in consensus, I mean, I would think is basically everyone in attendance. So in our view, in general, it's probably before you if it has substantial support from the work group. And I think that standard was met in this case. But it's fair to say it was not consensus. It was not unanimous. Obviously, Jim Allison's here just to speak to his concerns as well.
Yes, Alex and members, my recollection is to the contrary, that if there was not consensus among the work group, that the work group did not report a proposal to this committee. The committee, of course, as can the commission, can bring forward any proposal that it wants to. But the prior practice of the work group, my understanding was that it did not come forward from the work group unless there was consensus. Frankly, I think I and probably many others that participate in the work group will need to reconsider because up to this point, I think that's been a good rule, and it encourages broad participation in the work group. And frankly, if it's just going to be a majority vote in the work group as to what comes forward, I think a lot of us will probably reconsider whether it's good practice to participate.
Well, that's a good point.
And it certainly would encourage people to stuff the work group. And I don't think that's the purpose of the work group.
No, I think it gets a broad, gets broad views and it's valuable. So yeah, we wouldn't want to do that. I mean, I support it the way it's written, but I hear what you're saying. So that may be a good enough reason by itself.
Now, I think that members, any member, maybe somebody said this, of the Policies and Standards Committee or of the Commission can bring forth a legislative proposal on its own. But I kind of think this is not appropriate for us to do it this way.
So I understand this proposal. This would suggest or require counsel at the initial appearance. Is that what you're saying? This would ensure that if they are entitled to it?
No, not necessarily. Okay. It's just defining what Rothgary called a reasonable time, because we don't know what that means. And this would put in the statute when counsel must be appointed by. It's not necessarily the 15-17 hearing, no.
It would put in the 1 and 3 day deadlines, as I read it. And I think that's what the change in subparagraph J does, required in accordance with the timeline set forth in subsection C. And that was the language that, frankly, some of us strenuously opposed, because we feel like that's the whole purpose of the 1 and 3 day deadlines, was to make sure that people in custody got counsel appointed immediately to assist them, frankly, and hopefully getting out of their jail. And Rothgary just says a reasonable time. Clearly 6 months, as was the case in Rothgary, was not a reasonable time, but we don't feel that we should automatically adopt the 1 and 3 day deadlines for people that are not in custody. As pointed out, that's going to add a lot of cost, because many people who are not in custody, even though they may request counsel, may obtain privately retained counsel before their first court appearance. If we adopted this proposal, those people would all get automatic appointments before their first appearance. And I suggested a possible compromise, rather than putting in the 1 and 3 day deadline, to say before their first court appearance, not include that part about in accordance with the timelines. That would prevent the Rothgary type situation, where he didn't get counsel till he'd already been indicted, and didn't get it till he was brought back post indictment.
Why don't, if we don't take it up, then whoever proposed this, come talk to my office. I'd like to work on this one.
Yeah, I think it need, I think it needs a little bit more work, but I mean, I support it. Even as it's written now, I support it, but I can see why, you know, it may need some more help. So what do we want to do? Is there a motion for it now?
I mean, I'd file it even if you didn't propose it, to be honest with you. I mean, but I would work it up a little bit.
Yeah.
So even if I don't have the TIDC board behind it, it'll be something that I'm gonna look at.
Okay.
So I don't need a motion. I mean,
Yeah. I agree with you, and I'd be happy to work with you.
Okay.
So maybe it's not a TIDC. Why don't we just table it for now, and we'll talk some more, and let's move on to the next one.
And that's me, Alex, number 6.
Yes.
Page 27, and this is another one that came from Nate and the Texas Fair Defense Project. It's trying to address an issue they've been hearing about from defendants who are being housed in jails that are long distance from the county where they're being tried. So they're being held pretrial, and their local jail is full. We know places like Hays County are sending inmates all over the state. And the issue that they've been hearing about is folks not getting visits by from their attorneys. They have court-appointed counsel, but the attorneys report we're being paid a flat fee. It's a huge financial burden to make a large trek to go visit their clients. And so what's happening in a lot of cases is they're just not visiting their clients. So the proposal, as it came out of the work group, and it did go through some iterations, would require that those jurisdictions that do house inmates in jails more than 50 miles from the courthouse where the case is going to be heard must provide on their fee schedule for payment to support the travel to that location, or at least a method for remote secure communication. That was one of the additions that we made. I know Jim and others were involved in that. Obviously, in COVID times, there's a lot more remote communication options being made available to attorneys to meet and visit with their clients remotely, even within a county. So that's the proposal. And I think Nate is still here. If there's any questions.
Okay. Questions?
I'd move to adopt proposal number 6.
Great.
Second.
All in favor?
Aye.
It's approved unanimously. All right, number 7, Scott.
So proposal 7 was also brought by the Texas Fair Defense Project. It did not have consensus. So considering what was, I guess, the view that was expressed earlier about not bringing forward proposals that don't have consensus, I don't know how much you want me to go into it, but the proposal, the goal was really to put into place a process whereby defendants who had issues with their representation gave them a means of bringing that complaint to the court's attention and to have a hearing on a request for replacement counsel. And so that is the gist of the proposal. There was subgroups that worked on this. Issues that were raised were repeat requests for new counsel. So that was addressed by saying that a defendant does not have a right to a hearing more than a 6-month time frame has to go by from the first request to having a second hearing unless a new material issue is raised that could not have been raised at that first hearing. I don't know if y'all want me to go into it any further. Jim, Allison had issues with this one, and Nate is here to I guess answer any questions that you might have.
Well, Alex, I have some questions about the substance of the proposal, but before I get to them, what do you want to do about the fact that there was no consensus?
Yeah, I think it's another one to table. I mean, I'm the spirit of it, I think is great. And it's just hard to mandate what a judge should do in this situation. I think a good judge would try to find out what's going on, but to have, you know, a specific rule about how they do it is difficult to put in language. I mean, I think it is. I think that's what's the biggest problem with it is it's just, and it raised all these other questions about, well, does the lawyer need a lawyer and does the defendant need an ad litem? And I think there is an answer, but I don't think we got there yet. So, Chair Collier, what do you think?
I think it's going down into the weeds a little bit too much. I like the concept. I think they should have a right to raise the concerns and have a replacement counsel. But I'm concerned about how it's laid out in the specificity that's in there. So I don't want to sidestep the judge's discretion for particular cases. So I think that this one needs a little bit more work as we move forward. But the spirit of it, like you said, Alex, is good.
Yeah. So we'll table that and move on to number 8.
Hey, Alex?
Yeah, Jim.
In case I can't make the full commission, yes, Jim, my suggestion was just make the change in K to add or upon a showing of good cause, and not get down into all those details, because it looked to me like that was just creating a potential quagmire for the court. It seems to me right now the statute's silent about replacing an attorney for anything other than violating subsection J1. So you just add or upon a showing of good cause. That puts it clearly in the hands of the court, and they can do all this other without micromanaging it in the statute.
Well, that would be an improvement. I think folks also wanted some requirement on the court to
yes, we heard discussion, as I recall, about one judge who they felt like he needed micromanaging, and you know that may be, but you start putting all this detail in the statute, and it can create some mischief.
Okay. Well, for now, I think we'll just move ahead. So let's go on to 8. Scott?
Yes, sir. So this is a TIDC staff proposal. It was approved by the stakeholder group. The proposal seeks to modify the managed assigned counsel statute to explain the full array of services that are provided by MACs and codify the ability of a managed assigned counsel program to have an oversight board. And it would also allow managed assigned counsel programs to appoint counsel in capital cases. Right now, the statute regarding capital appointments does refer to public defender offices and public defender offices being able to represent capital defendants, but the statute does not reference managed assigned counsel programs, and it says, you know, it's basically either a public defender office or the process that is laid out in 26052. And so this would amend 26052 to allow MACs to appoint counsel in capital cases where that is not allowed right now. In terms of, you know, laying out what MACs do, you know, it adds a provision that says, you know, for the purpose of appointing or providing an investigator, expert, or other support services for appointed counsel or indigent defendants, and then it lays out the oversight board and who can be on the oversight board.
Yeah, I think that would be really helpful, especially here in Harris County, where we may end up in the situation where we get a MAC and the public defender's office is not doing capital work right now. So it would be great if there were a MAC that they were also had the authority to have authority over capital. So,
And the decision about whether a MAC should be appointing counsel in death penalty case would still be up to whoever creates the plan for the MAC, right? And that is, who's that? The county commissioners and the judges?
judges.
Okay.
Yes, it's
That's my
not,
only, yeah.
yeah, it's not required. It's still up to the judges to determine if the MAC would do that.
Okay. I'll move to adopt proposal number
8.
8.
All in favor?
Aye.
Okay. Did you say aye, Chair?
I'll say, I think it needs a little tweaking, but yes, aye.
All right. So that's carried. Number 9. Scott's going to explain it. It's actually my proposal.
Okay, so this proposal was brought to us by Alex, as he mentioned. It would direct TIDC to establish caseload standards and require counties to comply with those standards. Right now, TIDC is authorized to develop caseload standards pursuant to 79034A3 of the Government Code. And this proposal would essentially tell the commission to establish caseload standards. It would not tell them what those standards should be. It does not refer to the existing caseload guidelines as a requirement of those standards either. There was an earlier draft that referred to the guidelines that was taken out after some work group discussion. So there's not a reference to the guidelines. It just says TIDC should establish the standards. And there was also a lot of debate about enforcement and how would the caseload standards be enforced. And what we ended up coming to some consensus on is just referring to TIDC's enforcement provision in the Texas Administrative Code as to how those caseload standards would be enforced. It also says, per the suggestion of Jim Allison, that enforcement would only occur if TIDC provided more than 50% of the county's funding in the previous fiscal year.
So,
50% in the previous year? How many is that? How often does that happen?
Every year, we are provided with the amount of funds that a county spends on indigent defense, and we know how much money we gave to them in grant funding. And so it happens every year. I think that's what you're asking.
Well, I just want to know, I thought sometimes you don't give 50%. I thought sometimes you give 25%. You're only contributing 25%. And so if the goal is to require compliance, I don't need the qualifier.
Okay, that is correct. In most counties, we are not providing over 50% of the funding. It's typically like 10-12%.
Yeah. So if I'm going to support this, I definitely need to remove that requirement, that qualifier, that on the 50%. I think that if the purpose is to ensure compliance, whether you're giving them $1 or $500,000, you should be able to enforce that.
Alex, the reason for the 50% is that the only enforcement mechanism that the commission has is to require reimbursement of grant funding that's been provided or withhold grant funding in the future. If the state is not providing at least 50% of the funding, in effect withholding some portion or all of the 10, 15, 20, 25% they are providing, does nothing but punish our indigent defendants. And it's desired, it's of course what we've been trying to do is encourage the state to become a viable partner in the indigent defense process by providing at least 50%. And we now have achieved that in the Capital Public Defender Program, and we achieve it in our improvement grants. And that's the primary means right now by which we impose caseload standards. And that's very appropriate. Anytime the state is providing significant funding, I think 50% is a reasonable level. It certainly should, and I think appropriately could impose standards on caseloads. But until the state does that, in effect, they're just saying, no matter what your property tax base is, and frankly, in the larger counties, it's not a particular problem, but it is a problem in rural counties, and it is a problem in the valley, where funding is definitely difficult to obtain through property taxes. To impose caseload standards without the state meeting some level of funding certainly would not be equitable and not something we could support.
Okay. Well, I mean, I generally agree with you, but what I'm looking here for is a signpost to all the counties that this is what's acceptable. I mean, we generally don't get in the business of punishing them. I mean, really, since I've been on, been around the commission and on the commission, I can only think of one time that we punished the county, and it, you know, that was pretty short business because we ended up giving the money back. But I'm just looking to set a marker out there about what they should be doing. So the punishment side of it, I'm not as concerned about as the laying down what the rules are, which I don't think we've really done other than say there's a study out there.
Do we need subsection B then at all?
Well, I think that there should be an enforcement mechanism available, but I've seen the work that you guys have done, the investigative work, and you work with the counties and you try to help them improve their delivery model and their services. So I don't see this being abused, but I do believe it needs to be available. There should be some enforcement, because if we're going to protect someone's, you know, if we're going to provide, you know, fulfill our obligation to the right to counsel, we need to make sure that there's a metric, that there's some standard available. And if somebody is taking state dollars and not upholding that, then they should not be able to abuse it. But I mean, if you want to have some type of corrective measure added in between the pooling of funding, we can look at that later. But I do believe that there needs to be an enforcement mechanism.
Okay.
I had two quick comments. The first relates to something I said at the last meeting we had, and that was the difficulty in coming up with caseload standards that are reliable. Because as you know, we commissioned a study years ago to come up with guidelines, and based on the figures that we have now about how many indigent defendants get appointed counsel, it looked like half of indigent defendants who are appointed counsel received counsel who are overworked. I don't think that's true, but according to the guidelines, that's what the guidelines showed. And then, if you'll recall, Judge Torres, I think it was, pointed out that the figures that are reported to OCA about payment of counsel or appointment of counsel don't match the TIDC figures. So I think I'm not opposed to caseload standards. I think one of the really big challenges is coming up with something that's workable and reliable. In this case, though, I also wonder if we pass this and it gets to the full commission, why anybody would vote to ask the legislature to mandate something that we have decided as a commission not to do. We can do this on our own. And I don't know why we would want to be, we would vote to be mandated to do it. So those are my questions. I mean, overall, caseload standards might be fine. I think that the details, as y'all have been talking about too, about enforcement, make it very challenging.
Yeah, Judge, as to the last point, the reason I did seek it as a statute is because I think it's a big step, and I was looking for legislative approval. I realize we could construe it as part of what we could do now and put it in place, but because of it would have a huge effect, that I thought that it was appropriate to ask as a statute. That's why. As far as the effect, and that, yes, maybe as many as 50% of the appointed lawyers, I think you would find they're in a couple large urban jurisdictions that are the main outliers and the reason that I'm bringing this to the attention of the commission. Most counties would not be affected. It's Harris County, it's Dallas County.
It's not 50% of the attorneys, it's 50% of the defendants.
Yeah, but it
is in the big counties. Yeah, it is.
So, okay. Well, I realize it's not going to be an easy sell to the commission, but Chair Collier, did you want to move with your amendment? Because
yes.
You didn't like it the way it is, so.
Yeah, and so as long as what we're saying is that the TIDC would come up with the standards. So I think the reason why you codify it is so you can, make sure we know who's doing it, who's responsible for coming up with these standards, and they can be altered as times change. It may be that the number needs to expand or reduce, but that's something that can be adjusted within the TIDC's recommendation based on, whatever the ABA or whatever. So I would modify this by saying enforcement of the caseloads. TIDC can enforce the caseload standards, and then just leave it like that. I wouldn't put down only if they receive 50%. And you could say TIDC may enforce, so it's not required.
Okay. All right, so as amended, any further discussion on that?
If you're going to do that, Alex, I'd ask that you remove it from the consensus work group list, because our support of it, as you recall, was contingent upon the 50% funding level. And so if you would take it off of the work group recommendation and convert it to a standards policy committee.
I agree with that. Okay, it would just be the committee's motion and proposal. So with that, any other questions about the amended proposal from the committee? All right, all in favor?
Aye.
Aye.
I'm a no.
Okay, 2-1. All right, the last of the new proposals, Scott.
Ooh, so many Scott items.
Yeah.
All right, this is the last one. This is the last you'll hear from me. This last proposal was it was brought to the work group by Elise Ferguson, who's here with us. She is the director of the Managed Assigned Counsel program in Collin County that focuses on mental health cases. So Elise brought this proposal with the goal of getting a Managed Assigned Counsel director on TIDC's board right now, as exemplified by Alex. Public defender chiefs have a position on TIDC's board, but Managed Assigned Counsel directors do not have a position on the board. And so we started off this proposal by, modifying the statute so that it would say a MAC director or a member of the private bar, defense attorney, that slot that we have. It was felt by the stakeholder group that those two positions were not really analogous, that the MAC director position should be separate. And as such, there needed to be an additional person added so that the board had an odd number of persons. So what was the consensus was that that second person would be either someone who has been represented by assigned counsel or a family member of somebody who has been represented by assigned counsel. So those would be the two new additions to the board. And then during our discussions, we also discovered some hinky language related to the public defender chief and their ability to assign somebody else to their slot. And so we talked with Ledge Counsel about that. They said that, yeah, that was problematic language, that we should consider removing it. So we also removed that language as well. Elise, I don't know if you had anything you wanted to add?
Not really anything additional. I think my concern was being sure that the MACs were represented because our issues are distinctly different than the PD's office, was my primary concern.
Okay. Any questions for Elise or Scott?
No, I have a comment.
Yes.
When the membership of the commission was established at the beginning, there was, it was a very deliberate distribution of judges and other members. And if we start adding non-judges, we're going to upset the balance. This was supposed to be a judicially dominant commission. And so I would be opposed to upsetting the balance, which this would do. I don't have any problem with changing the language Scott was talking about at the end. I think that's fine. But I was going to suggest that we, sorry, Alex, but just that we have a chief defender from a PD's office or from a MAC and make that, or maybe even make it alternate from every few years or something. But if that would not address the problem, then I'd just say either no or limit it to making the correction that Scott was talking about. I think we're going to run into a lot of opposition if we do upset the balance, because that was done very deliberately when the statute was initially passed.
What do like medical boards and those other boards do when they have to, they expand the scope of practice and somebody else is added? Do they add, just, is it uneven, or do they just continue to add another entity to make it uneven, I guess? I don't know.
Well, this is two of them, isn't it? Former, is it both the MAC director and the former client, or is it one?
Both. It's two.
Both. So it would change. Right now, the governor has 5 appointments. This would change it to 7 gubernatorial appointments.
Yeah, so it's still going to be an odd number.
Right.
I think that I would, definitely believe that the MAC, there should be a representative from the MAC, but I other than that, I don't believe, I'm not sure how much value we could have with the former client, because I'm assuming that all these stakeholders and advocates are here to voice for those people. You're here to help us understand what's really going on the ground. So
I agree.
I would just, if we're going to do it, then maybe do a alternating, like Judge Keller said, or leave it alone.
Or we could add another judge if we want to make it, keep it an odd number. But,
Okay.
and I think adding another judge would solve the problem of the balance, the not upsetting the balance. But what would be wrong with having either having statute say either a chief public defender or the either an appointment or the director of a MAC?
I don't know that there would be anything wrong with it, except for the fact that there's a significant number of, there's a whole lot of chief public defenders right now. There's not a whole lot of MAC directors. They do have kind of distinct, I guess, perspectives and issues that they have to face. And so that would, I think, be the only thing you might consider in terms of, you know, on those off years when you don't have a PD chief, you know, you wouldn't have that voice at the table.
Do we have JPs on here?
Could you? I think you could, right?
We don't have, there's no JP slot. There's no way a JP could be on, is there, Wesley?
Not presently, no.
Right.
No.
So if you add a JP slot, I guess.
Yeah. That'd be fine.
I'm talking about for the
There's
MAC.
no-
You
For the
you have a
judge.
MAC and a JP.
Yeah.
Right.
There's no statutory court judge either, so you maybe rock in a different boat.
Say that again, sir?
So there's no judge of a statutory court, a county court at law.
Oh, I thought it did.
Yeah.
Oh, you're right. I don't see a county court. I see I see constitutional county court.
Right.
Oh, I see what you're saying. Yeah, I wouldn't want to jump down to the JPs without going, by going over the county courts.
To be clear, there is a statutory county court judge, and it's just not listed here as they're not a gubernatorial appointee. It's a member of the Texas Judicial Council designated to serve. So I don't think it's shown in the language we're looking at, because this is just the part dealing with gubernatorial appointments.
Oh, okay.
But we do have a statutory judge.
It's not required, but you do right now by virtue of that being their designated representative. Correct?
Right.
Judge Torres right now is the statutory county judge.
Wait, we only have one because this person happens to be a county court judge?
They happen to be on the judicial council, Yeah.
Okay, so if they're not on the judicial council, we would not have one.
or if the judicial council designates someone else.
Okay.
Yeah.
Then why don't we add the constitutional county court or whatever, statutory county court?
Can we, it doesn't sound like we're going to have consensus about the proposal that's before us. I would like to consider a way to add someone from a MAC. Can staff come up with a proposal that, you know what we're talking about? Okay, that would have, add someone from a MAC and add another judge that we could have before us at the meeting at the end of the month? Would that work, Jeff?
We could do that for sure.
Do you think that's a good idea?
I think,
Go
okay,
ahead.
I agree with Chair Collier that we have a position that's not represented of the judiciary. I
We
mean,
all
what
agree
else
on
would
that.
it be? Is it, what else? I mean, can we, is there some, I'm not sure what else it could be. I mean, we can, with that understanding, we can move it on and it can be fixed in the meantime, but.
That's fine. I mean, you can fix it, but I would definitely just say in place of that, we put a place marker, say MAC and a judge to be determined or something.
Okay,
Let's do
you know.
that.
Okay.
Let's do that and let staff kind of sort out the details.
that's fine. So,
We can work on that.
okay, you don't need a vote. We'll deal with it at the next meeting.
Okay.
All right, so now we have 4 proposals that we approved last time, but for whatever reason, they didn't make it all the way through. So Wesley, you want to describe what those were?
Sure. I'm going to hit the first 3, and Jeff, I think we hit the last one. I'll be very quick since y'all already talked a long time, and we've already adopted these, as you point out previously. The first one would repeal the requirement that public defender attorneys must inform the appointing judge of the results of any investigation into the financial circumstances of the client. This is actually a proposal from Alex's office, the Harris County Public Defender. It was filed last session. It passed the House, but it didn't make it through the whole process. There wasn't any opposition, but the concern is that that would violate attorney-client privilege, and that requirement doesn't exist for attorneys in private practice, only in the public defender statutes. It's kind of an odd provision to begin with, I think.
Yeah, it's not real complicated.
Yeah.
All right, next one.
Yeah, y'all may want to take these all up together. As
Yeah, let's
motion,
just,
but,
I'd like to take them. Yeah, let's take them together.
Yep.
okay, that sounds great. Number 12 then would specifically provide for the authority to make limited scope appointments of attorneys for purposes of representation at a magistration hearing, Article 1517 hearing. The current law says that once appointed, the attorney is to stay on a case until the case concludes or the judge removes them for good cause. And this, although was written long before there was any representation of magistration, it has been a cause of concern in each county that has elected to start providing counsel at magistration. And this would just make it clear that that is an acceptable practice. The counties that have done so through standing orders from the judges making limited scope appointments, but I think it would help in future to just have it clear.
Right. We do it in Harris County, but there was a question in Fort Bend whether they could do it, so that's why. 13?
Turning quickly, 13 is a related provision that would also dealing with representation at magistration, and it would allow attorneys with a private criminal practice to serve as part-time public defenders in a public defender's office for the purpose of providing representation at 1517. Right now, if you can't have an attorney in a public defender's office who has a private criminal law practice. And so this would permit it for this limited purpose. This was really an issue and still is. I confirmed with Fort Bend County Public Defender Office, who brought the idea forward last time. They actually hired attorneys who are civil attorneys to provide this representation, which is kind of a perverse way of having to deal with it, because they needed attorneys and the dockets conflicted, and so the only way to do it was through part-time attorneys, and they'd like to be able to hire folks who actually know something about criminal law coming in. They did remove this push that this would still be useful and helpful for them.
Okay. And 14, Jeff, you gonna explain?
Sure. This was a bill that was filed by Representative Andy Murr last session. It really does 2 things. One is just a cleanup bill for 79037. And the other part basically allows TIDC to fund nonprofits directly when those nonprofits are, their main purpose is to provide public defense in Texas counties. The examples that really kind of came up in the thing that was the impetus for this is you think about RPDO or the FIDDLE program or the PDEA program, where we have a program that benefits multiple counties, but right now we're using kind of a host county as a pass-through for funding as opposed to funding that nonprofit directly. So this would allow us to fund the nonprofit directly.
Great. Okay, so is there a motion for proposals 11, 12, 13, and 14?
So moved.
Okay. All in favor?
Aye.
Aye. All right, so that's all the legislative proposals. The next is the report on the 2019 Indigent Defense Plan submission and review status. Who's doing that?
Alex, I am.
Okay, Joel.
Yes, if you could please turn to page 51. So every 2 years, counties are required to submit all of their indigent defense plans to TIDC. Every county will submit at least 2 plans, a juvenile plan and an adult plan. And the adult plan may be split between felonies and misdemeanors. So this last submission due date was November 1st of 2019. And if a county has not had all their plans submitted by that time, they have a formula grant hold. Well, this last year, we have finally gotten all the counties on board and have submitted their plans. And so those formula grant holds have been removed for that. So at this point now, staff goes in and we review the plans to make sure that they meet statutory and administrative requirements as set by the TIDC board. And we're going through that process right now. There's a number of plans that have to be amended because there were some statutory changes. And in particular, there was a requirement that the public defender be given priority appointments. And then we're also looking at contracts in those counties that have contract defender systems. So right now we've looked at counties and we've cleared 110 of them as having met all these requirements. And so we still have a ways to go, but we're hoping to clear a number of those plans out in the very near future.
I'd mention really quickly that thanks to Lindsay Bellinger, our newest staff member, who worked really hard on this, and we actually cleared these a little bit earlier than we have in years past because of her help. So thank you, Lindsay.
Yes,
Very
thank you.
good.
Great. All right. Are you also covering policy monitoring report?
I am. If you could turn to the next page, beginning on page 52, have a summary of some recent policy monitoring activity. Since the March PNS meeting, we've received responses from 10 counties to monitoring reports, and we've also issued 5 new reports. These 5 new reports, they're a little different in the past than we have done in the past. We now have a quality assessment supplement that's sent along with the report. And so these new counties now are Tarrant County was an initial review, and we also sent the supplements to Gaines, Dawson, Deaf Smith, and Jefferson counties. The quality assessment, it seeks to be sure that or measure how well counties are able to ensure the quality of counsel services being offered. It does not include recommendations for the report, but it's a way to for counties to understand like how well they're meeting this requirement. And it's said in Article 2604 B5, where judges are supposed to ensure that attorneys can meet their ethical duties to their clients. And so going forward now, we had a COVID epidemic, and we also had a budget problem. Up until the COVID epidemic, we would sometimes do some part of our review offline, but a lot of the review was on site. And now we have travel restrictions as well as COVID restrictions. So we're doing our reviews virtually. And this has become a little bit of a challenge, but what we've done is we have adjusted our monitoring schedule to hit counties who were on the risk assessment as eligible counties, but who had electronic case files. And so we are trying to go through and do a whole virtual review with these counties. And so right now we're doing a follow-up review in Harris County and new reviews in Parker and Montgomery counties. And after those, we'll do reviews in Williamson, Tom Green, and Brazoria counties. I think we can do largely the same things that we did as in an in-person review. I think an in-person review is a little better, but these are the restrictions we're faced with, and I think we're doing okay with them. And that concludes my report.
Okay. Who's covering complaints? Kathleen? Oh,
Lindsay is.
Good afternoon. If you can turn to page 55 for a summary of recent complaints. We have received 42 complaints since the March 12th board meeting. 36 of those complaints do not require any further action. 16 complaints will result in referrals to the State Bar, 9 in referrals to the Innocence Projects, 2 to the Texas Jail Project, 2 to Self-Serve Legal Resources, and 1 of the complaints was forwarded on to local officials. 3 of the complaints alleged issues potentially within our scope out of Bastrop County. These complaints are all still under review. From the Just Us Participatory Defense Organization, The complainant indicated that 2 attorneys on the wheel have received a disproportionate number of cases, and that 1 attorney has a consistent caseload over the TIDC caseload guidelines. The second complaint is from Anna Harris, also of the Just Us Participatory Defense Organization. The complainant indicated that defendants are not given an opportunity to request counsel until their arraignment, which can happen 3 to 5 months after arrest. And then the third complaint was from Roxy Rodriguez, and the complainant indicated that in response to her request to meet with her appointed counsel, she received an email from her attorney who indicated that the county budgets 2.67 hours for flat fee payment for a guilty plea, and will not pay him or any other attorney for any additional time above the 2.67 hours. And that concludes the report.
All right. Next item is public comment. Oh, I'm sorry, Chair, go ahead.
Yes. So Joel, you were talking about your investigations. You know, you're not able to be in person, but are you doing them virtually?
Yes, Chair. Everything we're doing is virtually. We can see dockets. We can look at case files online. We're still challenged in maybe getting all the pieces of the case file and being able to see all dockets, but we are going through it and doing it.
But are you meeting with the people virtually, like you and I, we're here and I can see you, you can see me?
Yeah, everything that we meet with is virtual. We do have online defense attorney surveys, and yes, we're trying to meet with, do interviews online as well.
Okay, and then Lindsay, you mentioned these complaints. What are the consequences if they are found to be in violation?
Chair, so typically we review the complaint and determine whether it falls within TIDC's general scope, and then if so, whether an internal investigation should be opened up or whether the complaint should be taken into account in our annual examination of the risk assessment to determine what policy monitoring reviews may occur in the next year.
So nothing?
I'm
just saying.
Let me see if I can say this, and tell me if I'm wrong. If it is something that we have oversight over, we can add that county to our next upgraded monitoring. We can monitor, it goes into the consideration of whether we monitor it. Or I think more likely, I mean, more often what happens is that if there's a specific complaint that we do think might be a problem, we address it with the local authorities and try to get it resolved that way. Is that right, Jeff?
Yeah, that's pretty accurate. Yeah, I mean, it kind of depends on what the complaint is, Chair. But yeah, a couple different things will happen. I think as you saw in Lindsay's sheet, we'll oftentimes refer them to folks who can help them directly. And we try to focus on more systemic issues as opposed to individual issues, frankly, in part because of staff capacity. But it could also, as Judge Keller was saying, trigger a policy monitoring review, sometimes a limited scope review, or other times it'll go, as Lindsay was saying, straight into the risk assessment, which could trigger a full policy monitoring review. So it definitely, not that nothing happens, but when it's an individual case, especially an individual pending case, we tend not to get involved directly in the case.
Okay, because I'm not sure how you would respond to the last one that the attorney said, I'm only getting a flat fee. And because of that, and you've already entered a plea, the additional time that you're asking for, I will not be reimbursed for. So therefore, I've fulfilled my obligations and role for you. But this person, so I don't know, I mean, is it a policy issue that you make a recommendation on moving forward?
Most likely without, I don't think we've made a decision on that particular complaint, but without, just to zoom out a little bit, I think normally what would happen with something like that, and Bastrop is a good example of this, where we're getting multiple complaints from this area. We don't yet know, is this an issue with one attorney or is this a systemic issue? But we're getting enough complaints that it probably would trigger at least a limited scope review, if not a full review, because it sounds like something's going on there. And it sounds like we need to have our policy monitors out there.
And sometimes I think we I think in the past, sometimes we've gotten a hold of the local judges to find out what's going on or make sure they're aware of this. I think sometimes we send letters to the local judge to say, hey, we've gotten these complaints.
That's
so
right.
It depends on what the complaint is. And sometimes they can get resolved pretty quickly once the judge knows what's going on.
Yep, that's correct.
Okay, it just is concerning that they came from the same area. And then, you know, maybe you, like you said, Judge Keller, inquire into what's going on with the judges, ask them if they can provide some insight. But I mean, we're getting the complaints for a reason, so people are expecting us to take action.
Yeah, and that's why we get reports on these now.
Okay.
At every meeting, because we want to keep up with it. That's exactly right.
Perfect.
And that's a new organization there in Bastrop that is apparently very proactive. So that's why you're hearing from them.
Good.
Yeah, good.
All right. Public comment. How do you do that on Zoom? Any advice, Jeff? Public comment. Okay. Are there any public comments? Are there any new business? Any other items we should take up? Then that's all I've got. So adjourn.
Good job, Alex.
Thank you, Judge.
Thank you all.
Thank you.
Okay.
Adjourned at 4:39.
Thank you, everyone.
Bye.
All right, thank you.